Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and keep their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-1293 et al. Secretary of Labor, Mine Safety and Health Administration petitioner versus Nighthawk LLC and Federal Mine Safety and Health Review Commission. And case number 24-1294 et al. Secretary of Labor, Mine Safety and Health Administration petitioner versus Crimson Oak Grove Resources LLC et al. Ms. Maltz for the petitioner, Mr. Schmidt, amicus curiae for the respondent.
Ms. Maltz, good morning.
Good morning. May it please the court. I'm Susanna Maltz for the Secretary of Labor. With me at counsel's table is Ali Beydoun, also of the Secretary's office. I see that the court is, I'd like to reserve 2 minutes for rebuttal, please.
Can you raise that a little bit? I'm so hard of hearing.
Absolutely, I'm happy to.
Hear what you have to say.
And I'll speak up as well.
Great, thank you.
The Mine Act has a split enforcement scheme. It creates two distinct roles for the Secretary and the Commission. The Secretary enforces the Act and the Commission adjudicates disputes. But the Commission now asserts that it has the power to do both and review and approve the Secretary's enforcement decisions. As this court has reminded the Commission in the past, that is not its role. I will address the jurisdictional issues first. The orders in this case are collateral orders. They conclusively resolve a disputed issue, an important issue separate from the merits. This issue is important because it concerns the different roles of the Secretary and the Commission. It's analogous to a separation of powers concern.
So it seems to me, though, that you could get this issue resolved after there's the equivalent of a final judgment in the case, right? Because it seems like if this were remanded to the agency, there would be a hearing, and after the hearing, then there could be appellate review. Like, why shouldn't it? That's the norm, and why shouldn't it be done that way?
That is the norm. I think it would be very difficult for the Secretary to preserve that issue and get review of a decision, particularly if that decision were in her favor. It's not clear that the Secretary would have the authority to appeal a favorable decision.
She can't cross appeal, though, on the settlement issue?
It's not clear that she would be able to do that with this issue.
Have there ever been cross appeals?
There have been cross appeals in general, Your Honor, but I don't know that there have been cross appeals with respect to an issue relevant to the settlement portion of the case.
So why wouldn't that be a permissible appeal? Because I guess in the analogous district court context, everything is up for appeal after the final judgment, and I don't see why this would be any different.
Well, I think the court's decision in Meredith versus Fentrick has some language about whether or not the Secretary can appeal orders from just orders in general or only orders that she's aggrieved by under Section 106 of the Mine Act.
Well, you certainly think you're aggrieved.
Well, if we came out in trial, I'm sorry to speak over you.
No, not at all.
If these cases were remanded and they went through a trial, there's a possibility that the Secretary would win on the merits issues at trial. And it's not clear that she would be able to appeal this.
Well, she wouldn't be appeal in that case, but this is you've got 11 cases before us. Like one of these, either she wouldn't prevail, or the other side would appeal, and then she could cross appeal. I just don't see how this issue, which is a legal issue, is going to evade review indefinitely.
I don't concede that we wouldn't win every single one, Judge Pan, but I take your point. I think that the lack of clarity as to whether or not the Secretary could ever get review on this, depending on these various different outcomes, demonstrates that's sufficient to create an effective unreviewability in this case.
You also have that for decades, the Secretary has provided some explanation, whether it be as part of the settlement motions for vacator or the SNS designations. So why do we consider this when you're thinking about the Cohen factors, particularly second and third prong of Cohen? Why is this of such importance, that we would overturn, or that it would meet those factors or not meet those factors?
So it's not the case that the secretary has provided explanations for vacatures and SNS removals in her settlement, proposed settlement motions. It is the case that she's provided, robust explanations as to changes in the penalty, and those speak to the penalty factors under Section 110I of the Mine Act. But the secretary has not explained her vacature removals typically, or her vacatures of citations or her SNS removals typically.
She never has?
No, it's not that she has here and there, there are thousands of cases.
But that's what I'm getting at.
Yeah.
Go ahead.
Oh, go ahead.
I'm finished.
I mean, before you've taken the position here today, if a ALJ asked the secretary for her reasons for vacating SNS or dismissing a citation, would the secretary have responded?
No.
It seems like this is a new position that you're taking.
No, this is the position that the secretary has taken since Mechanicsville and since RBK. Now, I'm aware, I think in RBK.
So I want to understand your answer then, because I thought you just said that if in the past an ALJ asked the secretary, why have you done this? She would have responded, because now her policy is, I can't respond to that, or I won't respond to that.
If in the past, I'm sorry, I just want to make sure that I'm answering with clarity. If in the past, an ALJ, prior to these orders, if an ALJ asked the secretary, justify your reason for vacating a citation or removing an SNS designation from a citation, the secretary would not do that since RBK and since Mechanicsville. It is the case that the secretary has not justified those decisions.
So she has consistently
That's
refused
right.
to justify these types of.
That's right. And the commission has, until these orders, the commission has accepted that. And the commission has reaffirmed the secretary's enforcement authority and prosecutorial power. I think in Black Beauty Coal, we've cited some North American drillers in our briefs. We've cited some cases in the past where the commission has affirmed the secretary's authority to vacate and to remove SNS.
Well, she certainly has the authority to do that. The question
Without
is whether she has to explain it so that it can be reviewed under the statute. And
Yes.
I guess what I'm hearing from you, I had assumed that it was a change of position by the secretary, but you're telling me it was a change of position by the commission.
That's right.
Because the commission used to accept that this was a prosecutorial thing and they never would.
Yes, that's correct.
But
Don't
is this
think there was
not
any
the same issue that was brought up and abandoned by the secretary in the American Coal litigation?
So I don't know that I understand that.
Regarding
Relationship.
the American Coal litigation from 2016, did this issue not get addressed and then abandoned?
With respect to the secretary's
Yes.
authority. So my understanding of the American Coal litigation is that there was a question as to whether or not the secretary had to justify, certain factual circumstances having to do with the penalty issues. And the secretary agrees that she has to justify the proposed penalty or, any changes to the proposed penalty and settlement. But I don't know that American Coal addressed the secretary's authority to remove SNS or vacate citations without review by the commission. And that's, that is not, I'm certain that that's not the case in American Coal.
So if we can go back to the jurisdictional issue, it just seems that the collateral order doctrine has been really viewed narrowly by the Supreme Court. And it's only been accepted by the Supreme Court in instances where it seems that the interest is in just not having to litigate, immunity cases, qualified immunity, sovereign immunity, 11th Amendment immunity. And this is just not that kind of case. And I know that there is a provision under the third prong of the Cohen test that says, finality, and then if it's a really important issue, essentially. And I just don't see how this situation before us fits in with the other types of situations where the Supreme Court has approved applying the collateral order doctrine.
So I think we've made the point that it's analogous to a separation of powers concern. The adjudicatory agency is encroaching on the
It's analogous,
secretary's.
but you're all in the same branch of the government. So it isn't really a separation of powers.
I understand. It is not a constitutional issue, but there is this issue of the adjudicatory body encroaching on the prosecutorial enforcement authority of an enforcing arm. And
I guess that's the best you can do, but if that's very different in kind from immunity doctrines, which is what the Supreme Court has approved.
If that is, yeah, I can't quibble with that, Judge, but these orders here meet the collateral order test, and they are incredibly important, in general, to the effective administration of the statute. If the commission is playing the role of prosecutor and adjudicator.
But why does it need to be decided immediately now? Like, back to my first question, you can just litigate this after there's the equivalent of a final judgment.
It's our position that it's not clear that we would be able to do that.
At some point, you would be able to over a course of all of these cases.
I don't
say it's a legal issue that applies across many, many cases, and eventually you'll get to litigate this. I don't see what the emergency is.
So insofar as there are practical concerns, I'm happy to speak about the immediacy of those. The secretary needs to be able to preserve her prosecutorial authority and not allow the commission to make her prosecutorial decisions.
Well, it appears that she has, because the commission, this was interesting to me too, because basically my understanding is secretary came forward with settlement proposal. Settlement proposal says we're getting rid of SNS, or we're, dismissing citations. ALJ says, why are you doing that? Secretary says, not telling you. And then the ALJ says, okay, well, I'll just approve it. I just won't approve it then because of this. The secretary has not lost her ability to not give this information, because the ALJ, for whatever reason, isn't insisting and isn't, I don't know, holding her in contempt, whatever the equivalent would be in this context. But she's not being forced to disclose this information. The ALJs are just taking it.
But she's not able to settle the cases or, to go forward either. And so that's her concern here, is that she's not able to exercise that power.
But then that's a different interest that you're asserting. First, you said it's really important that she be able to exercise her prosecutorial discretion and not tell. She's not losing that power because she's not telling. And then you fall back on, well, now she has to go to trial. But that's what everybody says about trying to do an interlocutory appeal.
The interest,
so you have no special interest.
The interest that we are putting forward is her interest in preserving her prosecutorial power,
which she has preserved.
Yes, for now, and
right.
Pending a decision from this court.
Right, but again, I just don't see why you can't go through the normal process and then raise this after the equivalent of a final judgment.
I take your point, Judge Pan. I do. It is our position that these are effectively unreviewable, and we're not clear that we could get review after final order.
I just don't understand why that's the case across all of the cases that you're litigating.
Well, there's just not
going to get this reviewed.
A certainty that we would be able to appeal, from this issue if it were preserved through trial litigation that didn't have to do with the settlement, and then if we were able to prevail at trial on, imagine that the secretary did not vacate the SNS because she didn't. So imagine the secretary went through on one of these citations that she would have vacated and won. It's not clear that she would be able to appeal then that issue.
Why is that unclear?
Well, we don't have case law that suggests that she would be able to do that.
So you can raise it.
We could try. I do concede that we could try, but it is, what our position is that is a narrow path, possibly an impossible
path. It is, but I just think the Cohen factors is a very high standard for you, and I just don't.
I understand.
I'm not hearing from you any urgency here.
There is urgency here.
But by the secretary's own admission in response to the rule to show cause, she can raise the issue about the scope of her authority on appeal, right?
She may be able to, but I think that's our concern, is that, if we could preserve that issue, the scope of her authority to vacate, and without review from the commission in a settlement context, if she then goes through trial, if she can preserve that issue, then, it's not clear that she could appeal that issue, particularly especially if she won the case. We could try a novel appeal on a favorable order, but it's just not clear that we would be able to get review there. I see I'm very, very close to my time. I want to make sure that I don't offend the court by going too far into this, but I'm happy to continue to discuss the jurisdictional issues, or I'll just speak briefly on them.
Continue talking until we have questions.
The merits. All right. Well, in that case, if there are other questions regarding the collateral orders issue, I'm happy to discuss them. The parties in this case are adverse. I'm aware that there's an Article 3 concern. The parties in this case are adverse the secretary has issued citations and the operators have contested them. So that creates an adversity. It would be sort of absurd if this court could not give relief for lack of adversity, and then the parties returned to the ALJ on remand and then went to trial. I'm happy to speak more about that, or I'll move quickly to our merits position. So I think at the heart of this case is the fact that the statute gives the commission limited review authority over proposed penalties that have been contested under Section 105. SNS designations and vacatures are not penalties. I'm very happy to take questions sort of about our merits position, but that is the heart of it.
All right, we'll give you a couple of minutes to reply.
Thank you very much.
Mr. Schmidt.
Thank you, Judge Henderson. Soren Schmidt as court-appointed amicus. With me at council table is Patrick Powers, my colleague with me on the briefs. Congress created the Federal Mine Safety and Health Review Commission to address a disastrous pattern of lenient settlement agreements between mine operators and government enforcers. In these consolidated appeals, the Secretary seeks an exemption from the reason-giving requirements that Congress created in order to avoid such settlements in the future. Her appeals are deficient for 3 reasons. First, the Commission should be here. It has a direct stake in the outcome of this appeal, and without it, the remaining parties are not adverse. Second, these appeals are premature. The Secretary can press her claims of prosecutorial discretion on appeal from a final order of the Commission as required by law. Any delay between now and then will not imperil substantial public interest. Finally, the Secretary's appeals lack merit. When she removes an SNS designation or vacates a citation in the context of a settlement agreement, contested penalties are compromised by mutual concessions, mitigated in harshness, and ultimately settled by agreement. That triggers Section 110K's approval requirements 3 times over. The Secretary's contrary reading would evade the accountability that Congress created to protect mine workers and eviscerate the text of Section 110K. I welcome the court's questions.
I guess on your question on your argument that the commission needs to be here, I find that a really difficult position for you to support, because if it's true that parties are no longer adverse as soon as they've reached a settlement agreement, even before it's been approved, then doesn't the district court lose jurisdiction over every case where there's a settlement or there's a plea agreement?
Not at all, Your Honor. In district court proceedings, the district court remains jurisdiction over the entire controversy, which can include the initial disagreement between the parties and the potential for them to, for example,
settle the whole thing. What if they've settled every issue?
So even settling an issue leaves open the possibility of reopener. For example, in the digital equipment case from the Supreme Court, that's where a district court had initially approved a settlement in a trademark dispute, but later the parties moved to reopen it. So it's necessary.
Why is this different from the Mine Act cases?
So the difference here, Your Honor, is that on appeal, there's a single issue, and on that single issue, the parties are not adverse in any respect. So the single issue is whether the Secretary required approval from the Commission in order to
So if there's an
remove these.
appeal of an issue that involves a settlement in the district court, we wouldn't have jurisdiction of that either?
No, Your Honor, because typically those appeals would be coming from, for example, a final order where there would be an adverse decision one way or another against the parties. And in that position, they would have the standing to appeal. They would have adverse interests on appeal.
So what if the district court rejected a plea agreement between the government and the defendant, and both the government and the defendant thinks that plea agreement is good and they take the same position on appeal? Do we have jurisdiction over that case?
Yes, you would, Your Honor. And that's because, for example, as the plea bargain cases cited in our brief show, that case would have eventually gone before the district court onto sentencing. And from there would be grounds to do a final order appeal. And that final order and the winner and loser before the district court would provide the adversity necessary for the appeal in general. And then as to the particular issue that they were raising, ventilating about an earlier error of the district court.
So you think that our jurisdiction hinges on a case-by-case analysis of what happens in each individual case after a settlement?
No, Your Honor. I think what I'm saying is looking at, for example, this court's precedent in cases like Cortez, there the court explained that in order for there to be adversity on appeal, the parties need to have adverse interests, meaning that there's a winner and loser below, so there can be a loser and a winner on appeal.
I just don't see why there's not also a winner and a loser in a Mine Act safety situation, because ultimately they are adverse because there's been a citation issued against the mine or the mine company, and they are ultimately adverse. Just because they settled it doesn't change that.
That's right, Your Honor, and it doesn't change that before the commission. But as to this appeal, where the parties are in total agreement, there is more of an adversity problem. Because here, just for example, if the secretary succeeds on her merits claim and wins, there won't be any party to seek rehearing or file an appeal or seek cert of that decision.
We appoint amicus like himself.
Well, an amicus, to my understanding, Your Honor, can help provide oppositional arguments, and I'm certainly going to try to do my best there. But there's a different aspect of adversity, which is the idea of adverse interests. And that's what, for example, motivates a party who has rights to file an appeal or develop strategic support for the case, things that are beyond the scope of appointment for an amicus. Here, for example, at least I'm not aware of any situation where a court has appointed an amicus to decide whether to seek rehearing or file an appeal of some kind, because traditionally that's a role that's reserved exclusively to parties. This, by the way, is what distinguishes this case from situations where, for example, the government confesses error below, or the Supreme Court's practice of appointing amicus, because there, even where the government is confessing error on appeal, they won below and have something to lose on appeal. And those are the adverse interests that this court explained in Cortez are essential to this court's jurisdiction on appeal. I will note, though, just to not fight too hard on this, Your Honor, that I think the key distinction between this case and cases like Oil and Henderson is that the commission is in the position of having direct stakes in the outcome of the appeal. Typically,
why does it have direct stakes any more than a district court does?
Because typically when a district court is ruling on a case before it, it's resolving a dispute as between the parties themselves, not a dispute about the scope of its own authority, as the commission was here.
I think that's true. I mean, if the district court says, I get to, approve your appeal or not, and somebody contests that, it's the same as a commission saying, I get to approve your appeal or not. I just don't see what the difference is.
Yeah.
Neither of them has a personal or I guess a party type stake in these proceedings. They're just ruling on this, and you are challenged, or the parties are challenging whether they ruled correctly or not. I just don't see how that has anything to do with the commission's own interests or the district court's own interests. Other than, I guess, you like to be affirmed, but other than that, I just don't see that they have any interest, institutional interest in the outcome of any case.
In run-of-the-mill cases, I believe that's true, Your Honor. For example, the commission has no interest in whether a particular citation was correctly brought or what the right penalty amount should be, other than, of course, it would like to be affirmed. But here it has an institutional interest in the scope of its own authority grant under Section 110K.
The logical outgrowth of that argument is the district court has a personal or institutional interest whenever it asserts authority to do something that the parties say it can't do. And that just can't be right.
I think that's true, Your Honor. There are, I think, note rare instances where, for example, a district court's authority is challenged through something like a writ of mandamus, and there the district court judge would be represented on appeal in that not quite personal capacity. But
even aside from the mandamus context, there are countless cases where the district court will assert an authority and the parties will say you don't have an authority to do that based on a statute, based on a rule, whatever. District court does not have an institutional interest in being more powerful to do this thing. Okay, it just doesn't. It's just being challenged. So I find this whole line of argument really puzzling.
That's fair, Your Honor. I think my position here is that reading this court's cases in Oil and Henderson is that those are distinguishable for the reasons that I've mentioned.
If we were to decide this case, basically stating that we don't have jurisdiction based on collateral orders doctrine, would you still say the commission is needed to be here to participate?
Not necessarily, Your Honor. You know, my submission is, of course, that the commission could have and should have been here from the start. But if this court were to reach a jurisdictional holding like that the collateral order doctrine does not apply, I don't think it would need to reach the issue of whether the commission needs to be here in the interim. It would probably need to confront that ultimately when the case comes back on final appeal. But at this time, for order of operations purposes, I don't think it would need to address it.
What's your understanding of the history of this issue? Because it seemed to me that I thought that the secretary was asserting this type of authority in this context for the first time in these cases, when there must have been many, many settlements that came before these cases in which it didn't arise. And it seems to me that the cases that your friend on the other side settled didn't deal with post-settlement dismissals. And I'm just curious as to why now? Why is this issue arising now?
Yeah, my understanding, Your Honor, is that there's a bit of a mixed history over the past couple of decades with some inconsistency about when and if the secretary is providing explanations for these kinds of changes to contested penalties. Again, this might be a place where, for example, the commission is better positioned institutionally to give you a more thorough answer. But I would point you to a couple of cases that I think are illustrative. So one is the American Aggregates Commission decision, which is cited in the briefs. There, my understanding is the commission required some form of explanation from the secretary for removing SNS designations. That's a 2020 decision. What had happened in that case is that the ALJ in the first instance applied a quite rigorous test to the removal of SNS designations. That went up to the commission. They said, no, that was too rigorous. You still need to apply our typical standard and our approval is required, but you were just a little too exacting in the scrutiny. So
there was no contest as to the authority to review it. It was just the standard that was applied was too rigorous.
That's right in the American Aggregates case. Yes.
So in that case, then the secretary did provide information about why.
I'm actually not sure how ultimately that case was resolved, Your Honor.
I mean, even.
Even before the commission's decision?
Because it seems to me that the issue before us now is if the ALJ wants to approve these settlements, the ALJ might ask, why did you dismiss the SNS? And the secretary is saying, I don't have to tell you that because I have prosecutorial discretion. And there are cases that I've seen where the secretary didn't provide an explanation and then the ALJ would just say, do the facts support an SNS or not, which is not the same as approving a settlement in which an SNS is dismissed, because you could just dismiss an SNS for reasons unrelated to whether it's factually supported. It could be a give and take. It could be a bargain.
Totally.
So I guess my question is, in the case that you just cited, was it on all fours with this case where the ALJ said, why did you dismiss that SNS? And did the secretary tell them why? And then he applied too rigorous a standard. Or did this ALJ just do that without requiring the secretary to explain herself?
Yeah, my understanding is the former, Your Honor, where there was some explanation provided, but the ALJ didn't accept that and applied more of a rigorous standard. I don't have it fully at my fingertips.
But an explanation was provided about the SNS
That's
specifically.
Right. That's right.
So the secretary didn't say, I don't have to tell you anything about why I'm doing this, because I have prosecutorial discretion.
At least not to my memory. Okay. No, Your Honor, I don't want to speak too authoritatively without having refreshed myself, but that's my recollection at least.
Okay.
The other case I would just note along that line is the PC Sand and Gravel case, which is from 2010. That's an ALJ decision where the ALJ, the secretary wanted to vacate citations as part of a settlement agreement. Mm-hmm. The ALJ said, hey, I'd like some reasons for that. The secretary initially resisted, but then ultimately did provide those reasons. So that's another example of where, at least as recently as 2010, the secretary has provided explanation for them.
Thank you.
All right.
All right. If there's nothing further, thank you, Your Honor. I'd ask the
You were
court.
appointed by the court.
Pardon?
You were appointed by the court and you've done an outstanding job and we thank you.
Thank you, Your Honor. It's my privilege.
Mm-hmm. All right, Ms. Falls, why don't you take 2 minutes?
Thank you. So I'd like to just clear up the history of this issue, the question about the history of this issue. The commission has never required before these orders the secretary to justify her decision to vacate a citation or her decision to remove SNS.
What about PC Sand and Gravel?
If PC Sand and Gravel is an ALJ case, it's non-precedential. I'm sorry, I don't have it at my.
It's not about non-presidential or not. You're saying she's never done it before, but your friend on the other side says in this case, she was asked, why are you vacating these? And she did provide reasons.
Well, if that's the case, then I don't believe that case holds that she was required to do that. I think there's a distinction.
That wasn't the question. I had asked, have you ever done this before, whether it's required or not? And you had said, no, she never has. But apparently
well, let me clarify that.
Okay.
Certainly at times, it seems that in RBK, for example, the secretary said, we're vacating these citations for lack of jurisdiction. There have been times where the secretary has, included an explanation, but there's never been a requirement that she do so. And, typically she does not do so.
But that wasn't the question I had asked you, though.
So I do apologize if I misrepresented
yes.
that. The secretary has at times provided an explanation here and there in the thousands of settlement proposals that she's submitted, but it's not a requirement. It's not ever been a requirement of the commission prior to these case. Well, I suppose it hasn't been a requirement since RBK and Mechanicsville in the commission's in the past 30 years. And when the secretary has provided those explanations, it's not because she's required to, it's just sort of, there are a few anomalous cases where she has included an explanation that she wasn't required to give. Are
vacators and the SMS designations or redesignations required to be part of the settlement agreement? So
let me see if I'm answering this clearly. In the settlement proposal, in the motions with the proposed settlement, the secretary includes that she has vacated a citation or that she has removed SNS, but she does not include typically an explanation about that decision. But the fact of it is included there. So again, just to make sure I'm being perfectly clear about the history of this issue, the commission has recognized the secretary's total discretionary authority to vacate a citation without its review in several cases in the past. I've got a quote from Black Beauty here that I don't want to read to the court, but essentially it says that the commission doesn't have review authority over the secretary's enforcement decision to vacate a citation. And that's been the commission's position. The commission and the secretary have agreed.
But that's contesting.
No, I believe that's post-contest. And that's been.
I don't think that's right. I don't think we haven't been able to find any case that addresses this post-contest. Well, because of course there's prosecutorial discretion, but there's actually a statutory provision that says after contest, it has to be approved. And we haven't found any case on point.
Well, I disagree with the
post-contest.
I disagree with the point that it has to be that these decisions have to be approved post-contest under 110K. 110K deals only with proposed penalties, not with vacatures.
And penalties can't be separated from the issues that arose with the penalties. And the language is broad. It doesn't say just penalties. It says mitigating all these other things that deal more than just a monetary up and down.
I disagree.
And in other parts of the statute, even cited in your brief, they say monetary penalties. So when they mean monetary penalties, they say so. So we don't need to get into, I don't think, these merits, because I tend to think that there's no jurisdiction.
Well, perhaps I should turn, I don't want to go over my time. Mm-hmm. I'm happy to discuss the collateral orders.
Question.
Oh, I'm sorry. Can you repeat the question that I've left hanging?
I guess ultimately, I didn't see any cases on point that said post-contest, the secretary has absolute discretion to dismiss things or, et cetera, without approval of the commission, that your argument of discretion doesn't extend to that time period after there's been a contest. And your argument just seems to hang on parsing the word penalty in a way that makes very little sense to me. So I apologize if I misunderstood this, but each of those cases arises in a post-contest. All of the cases that we've cited, because they are, under review by the commission, arise in a post-contest context. The operators have contested. But post-contest dismissal and then refusal to explain. So there are no cases like that.
I believe that that's Mechanicsville and that's American Aggregates and RBK. and I apologize that I think I'm just missing something fundamental about your question, but insofar as the commission doesn't say this is, the secretary has absolute discretion post contest, that the literal inclusion of that, I think that that's fair, but that's what those cases mean.
I understand your position.
All right, no more questions.
Thank you.
Case number 25-5269. HMO Louisiana Inc. Appellant versus Department of Health and Human Services et al. Mr. Warner for the appellant, Mr. Whitley for the appellees.
Good morning, Mr. Warner.
Good morning, Judge Henderson, and may it please the court. Paul Warner on behalf of Louisiana HMO. May I please reserve 1 minute for rebuttal? Our healthcare system is complicated. This case is not. The agency here simply refused to apply the plain text of its own binding technical note. And in doing so, it violated the APA in at least 3 different ways. Fundamentally, for this court, this case is totally controlled by the Propac Pharma case. If you will recall, was a 2004 decision written by Judge Tatel. And in that case, the court considered the FDA's switch of its interpretation or understanding of the word use under the Orange Book. And there the court decided that the FDA had not explained, and in failing to explain, it was the height of arbitrary and capricious decision-making. That goes here too. The agency offered 5 words to explain its departure. It didn't explain it, offered 5 words of justification for departing from its own technical notes. It offered no explanation, and you're not going to hear any argument from government counsel today that is not a post hoc justification for that fundamental move.
There's a very curious aspect of this case that is not addressed in your briefs, which is that the reason the agency did what it did, what you're challenging on appeal, is because you asked it to do that.
Right. And I think
why is that not addressed in your briefs?
We did address it, I believe, in a footnote in our brief. And I think what the court should understand is the timeline and context here. Our client, prior to litigation, prior to engaging outside counsel, repeatedly requested information from the agency on how it calculated its scores, given the fundamental decrease in score year over year. The agency stonewalled. Then we sued. Then we engaged in settlement discussions with the agency and got behind the green curtain and had an understanding of what it actually did. Then we focused in on CO5 and brought this particular challenge for its departure from the technical notes. That is the only measure that is at issue in our complaint.
No, I
before the
understand
court.
that, but it just seems that what the agency did was exactly what you asked it to do.
What we had asked it to do before we had any information, before our client had outside counsel, and in the context of trying to resolve this short of litigation, when our client did not understand what the agency had actually done.
Well, it seems that your client believed that the interpretation at issue before us was going to be favorable to it because it believed that the consumed contracts score was a 5. It was going to be really high and it was going to bring up the overall rating. But they were wrong about that.
Again,
that doesn't mean that the methodology is wrong.
No, it doesn't mean the methodology is wrong, but our client was making assumptions based on what it understood the agency had done
I
before it
understand that,
actually
but
did that.
whatever the reason, it took a position about the methodology that appears consistent with what the regulations and the technical notes insist upon. And so they were right about that. They were just wrong about factually how it would affect their score.
They were
So
actually.
it seems that it just seems from where I sit that you're just taking whatever position gives them a higher score as opposed to what's the correct way to interpret the regulations and the technical notes.
They weren't actually wrong just about how factually it applied. They're also wrong legally. And ultimately, it doesn't matter. Even if our client asked the agency to do something, the agency is still duty bound to actually articulate a reasonable justification for its change in policy.
I understand that, but it's just very curious to me that you then come in here and say this is arbitrary and capricious and nobody could know what they were doing when you knew exactly what they were doing because they did what you asked them to do.
We did not know what they were doing. We asked them to do something before we had known what they were doing. And once we understood it, once we got the data and
Once you
understood how they
understood how it would
calculated
affect your score, then you said the methodology is
True.
correct because it lowers your score.
That's true.
But it's exactly the methodology you asked for.
But that's part of the iterative process as part of calculating the scores. And that is where we understood the agency
I
went
understand.
wrong.
I think you're in a difficult position. But I just think it just looks like it's a very results-oriented legal position because if your score were to be higher with this methodology, you'd be happy with it. But because your score is lower, you're challenging it. But then you're saying it's arbitrary and capricious when it's not because you asked for it.
Well, that's true. But again,
it didn't come out of the blue.
It didn't
It's what
come.
you asked for.
It didn't come entirely out of the blue. But again, the timeline matters here. When we asked and what it did and how it did it, and our understanding of
It only
what
matters
it
in
did.
terms of what your score ended up being.
Yes, of course. And again, it's important to roll the camera back and understand the practical implications of the agency's ruling here.
Which is
Those
really
5
the
words.
that you lose, and that's why you're here.
Yes, we do. But those 5 words also matter. They impact the care of 34,000 different
But I still
beneficiaries.
don't understand what you are perceiving to be the methodology because, pursuant to Judge Pan's questioning here, you still end up with like a 3.5 score, regardless of the approaches that the agency took on the initial position and then what you've actually asked them to do. And then either way you go, when you weight other factors, that kind of also dilutes how the score will come out.
Well, right. But all we're asking for the agency to do is actually apply the technical notes that it itself adopted. And here that would make a change in the relevant C score. And the way the regulation works in with respect to the technical notes is important for the court to understand. It's like if you're driving down the highway and a light on your dashboard pops up. You go look at the manual and it says you need to change the oil. Then you go further in the manual and you see how you're supposed to change the oil. That's the way the regulations work with the technical notes. You look at the regulation says calculate a score. The technical notes say how you're supposed to do that. If you go back to the car analogy, if you see you're supposed to change the oil with 30 weight oil, you don't go back and say, well, it just says change the oil so I can use milk and honey or whatever else I want to put down there. You change the oil with oil.
About that. So if you've got H. Muller's position regarding what happened to H5576, was it consumed? Was it a consumed contract in consolidation or was it a terminated contract?
It was consumed, which means it ends, which means it's terminated. Again, this semantic.
But consumed and termination seem to be different.
No, they're the same. And if you look at common usage, a contract that ends is in fact terminated. There's nothing in the regulations.
Termination is defined.
Yeah, it's defined.
It is not defined.
It is.
Termination
It's
is
by
not.
mutual consent, or this is what 42 CFR 422.508, mutual consent, or if a CMS determines the MA organization has neglected its duties, or by the MA organization if CMS fails to substantially carry out the terms of a contract.
Actually,
It doesn't include consumed.
It says those are ways that a contract may be terminated. It's not exclusive, and a consumed contract is terminated because it
But your
ends.
definition of consumed equals terminated makes no sense with the way you're supposed to calculate the score. It has to be a weighted average with the consumed contract, which means it's not terminated.
This is a position that the agency itself never offered in its decision. It would be improper for the court to
But how
go
is
down
that
the semantic
consistent
rabbit hole.
with that aspect of the
There's nothing-
regulation?
there's nothing
The
in-
regulations say when you calculate the score of a consolidated contract, you take the weighted average of the consumed and the surviving, the two prior ones. And if the consumed were always terminated, you could never have this formula.
If you look at JA 267 and also 194 and 195, it says you take all the contracts and then you look at whether any are excluded. The plain language of the exclusion says you take out contracts
You're not answering
with
my
an end
question.
date.
How is that consistent with the normal formula for
It's an
calculating the
exception.
score?
It is an exception to the normal
But if you
formula.
ever use the consumed, then it's not terminated.
That is the way the technical notes properly work. That is the plain language of the technical notes that the agency
You're not
itself
answering my
wrote.
question.
I am. I'm trying to.
So here's the question. The question is, if the standard formula for calculating the overall score after two contracts are consolidated requires a weighted average of the surviving contract and the consumed contract, how is it possible that the consumed contract is ever terminated? Because you're always, the default, the norm is to average in the consumed contract score.
You would take that out because the data is not reliable. That's what the
So you're
exclusions
saying
are
this
for.
this
Yes.
formula is wrong.
No, the formula works the way it works. It says the
How does it
nature.
ever work if the consumed contract is always terminated?
You would, for this particular measure, you would always take it out.
So
if
only
it's
for
in fact
CO5?
terminated. Only, all of the notes are different. They have different exclusions. Every single measure is unique and it's based on the
But
service
why
that's
is
being
your
measured here.
interpretation the best interpretation when it conflicts in this way? When the most normal and natural reading would be that consumed does not equal terminated?
I don't agree that it conflicts in any way.
Well,
The
should we try to
technical
read
notes-
this to reconcile all the different
Actually,
regulations and notes?
what this court should do is look to what the agency actually did and evaluate that. And it hasn't offered any
That's what we're doing,
justification.
but shouldn't the correct interpretation of what they did and whether it's correct or not depend on reconciling these different regulations and rules?
Of course, they all fit
So
together.
why is it not that their interpretation reconciles it and yours does not?
They don't have any interpretation. What they have are post hoc rationalizations. The agency didn't offer any interpretation along those lines
Well,
at
why
all.
would the technical notes require CMS to consider data prior to June 2015? I mean, June 15.
I'm sorry.
Why would the technical notes require CMS to consider data prior to June 15?
It would not. That's the data that's supposed to be excluded because it can't be validated. The reason for the exclusions, it looks at plans with certain few enrollees and also data that isn't reliable. That's what gets excluded. Those are why those particular contracts that are terminated or end are excluded because the data is invalid and it will lead to an improper score. And
Why
in
is
turn,
it invalid and why is it improper? The new contract has the CO5 provision. So doesn't the consumer want to know the basis or the quality of that contract?
no, this is another mistaken argument that the government is now advancing on appeal. You look for the data for the measurement year. The measurement year is
Okay, so is it
2003.
correct? I understand, but is it, that's true for all of the ratings. So
True.
isn't it true that the new consolidated surviving contract, whatever you want to call it, the new contract that combines the two does offer the SNP that is the CO5 term? Does it offer it or not?
It
Yes or
did-
no?
I want to be clear.
Yes or no? Does it offer it or not?
It will offer it in 2025. It did not offer it during the measuring year. The measuring year was
I
2023.
understand that, but you're obfuscating.
No, I'm answering
You're
you directly.
obfuscating. The 2025 ratings always reflect 2023 data.
Yes.
It's not just this
But-
particular
right.
case. So the 2025 rating for this S&P, which has for this new contract that has an S&P, should reflect the 2023 rating for the S&P that's being offered,
Yes, that's
which
true.
includes the consumed contract.
No, it doesn't. You are offering the data for measuring year 2023. The go forward, the surviving contract in measuring year 2023 did not offer the S&P. The point
But
is,
the
if you were
consumed one did, and they're combined, and the 2025 one reflects both the consumed and the surviving.
no, that's not
No,
the way.
it doesn't?
That is not the way the technical notes actually work. You
No,
are
no,
to
tell me
take-
how this works then. The surviving the consolidated contract for 2025 combines the surviving and the consumed contract.
Right.
One of them had this S&P feature, the other one did not. Why should the 2025 one not include the rating for the one that did?
Because the 2025 plan is offering something new. The surviving contract did not have the S&P, and the terminated contract was in fact terminated. And based on the way the technical notes work, you are to exclude that. But again, we're having a discussion around a rationale that was never put forward by the agency itself. The APA requires the agency to come forward with the rationale, not for the district court or this court to backfill an explanation the agency itself never offered. And there
start out with different definitions of termination, and the regs identify only 3 types. You can have modification or termination of a contract by mutual consent. It can reference termination of a contract with CMS or discusses termination by the MA plan. Isn't that an exhaustive list?
It is not, because it says those are the ways a contract may terminate. It says nothing about how that relates to consumed contracts in a consolidation process. And if you look at the regulation itself, consumed contract means a contract that will no longer exist. In common everyday language, that means the contract has been terminated. I'm way out of time, and I'm happy to continue to answer questions.
We'll give you a couple of minutes to reply.
Thank you.
Mr. Whitley?
Good morning, and may it please the court. Special Assistant United States Attorney Kenneth Whitley on behalf of the government. The district court correctly granted summary judgment in CMS's favor. CMS's regulations are simple. CMS evaluates consolidated contracts on Measure CO5 for the second year after consolidation if either the consumed or surviving contract offers special needs plans in the measurement year and the consolidated contract is offering special needs plan in the star ratings year. HMO-LA's consolidated contract offered special needs plans in 2025, and its consumed contract offers special needs plans in 2023. CMS properly evaluated the consolidated contract on Measure CO5 for the 2025 star ratings period.
Let me just ask a basic question. How is this data received and performed? Is it all digital, electronic, or by humans?
For the Measure CO5 and Measure D11, the 2 measures that are predicated on Medicare Part C and D reported data, that data is reported through CMS's computer system.
Okay. The reason I ask is because CMS's initial position, there is a suggestion that there was a computer glitch early on.
Yes, Your Honor. For some reason, HMO-LA was unable to submit its special needs plan data for its consumed contract through the computer system. That was a one-off error that has, to CMS's understanding, never happened before. Indeed, in 2024, CMS evaluated.
Do you consider that data just not counted because of the computer glitch, or do you consider the contract terminated?
We consider when CMS learned of the computer glitch and HMO-LA's inability to submit data, it permitted HMO-LA to submit its data so that CMS could consider it in accordance with its regulations. The rule that HMO-LA is advocating is that the surviving contract must be the one offering special needs plans in the measurement year, but there's no support in CMS's regulations for that position. HMO-LA's contract consolidated on January 1st, 2024. For the first year after consolidation, CMS considered, like I said, the special needs plan for HMO-LA's consolidated contract. When CMS failed to do the same for the second year following consolidation, HMO-LA alerted CMS to the issue, and CMS considered the special needs plan data for the second year.
So let me start with D11, which of course isn't in this case, but D11 was offered, a measure that was offered by the surviving contract as well as the consumed contract. So the application it's not the same issue, but there's nothing in the record in this case that warrants going into the measure. So the government.
So counsel, I understand you're in a little bit of a difficult position because you're trying to achieve the highest score for your client. But just from the point of view of a court of law, we're trying to analyze and interpret provisions that are in regulations and in technical notes. And it just seems difficult for us to accept that you really believe that this is the correct interpretation or the best interpretation when it seems so driven by the results and not by just achieving the correct interpretation. Because if it benefits you, then you want whatever that interpretation is. And it's not even consistent across different types of I don't know what you call those.
There is nothing in the record to support
Provisions.
that. D11 is not an issue here. I can represent to you that we are not asking for different
Let me tell you what I see as supporting that. What I see as supporting that is you took the completely opposite position before the commission until you realized it hurt your score. And then so you changed your position. And then you come and ask for this position because you think it increases your score. But if this methodology that you're asking for were applied consistently across C05 and C11, it seems like that wouldn't change your score. So you only want it applied as to C05. I'm just telling you what it looks like to me.
Right.
Okay. And this is why it puts you in a difficult position because then you lose some credibility. It doesn't sound like you're trying to assist us in finding the best interpretation. It seems like you just want whatever interpretation will give you a higher score.
Well, that's the whole point of the iterative process with the agency is to evaluate, to get to the right score, to get to a score that is a true reflection of the plan's quality so that enrollees have accurate information about the plan when they're selecting and choosing which plan to enroll in. So it is a process to get to the right score. But in terms of what we are advocating here and the change in position, the change in position came after we were able to get behind the green curtain and see how the agency was actually using the data. And we are not advocating for a different application for C and D. Those measures are different. The exclusions are different. And D actually had a surviving contract as well. And if you look, again, if you look at the agency's...
The difference between C and D is just that whatever the provision is, one was in the consumed contract and the other was in the surviving contract.
They are different, but more fundamentally, if
That's not the way the formula works. It's a weighted average of both.
It's a weighted average of both, except if you exclude certain data under the technical notes, which are binding. The agency's conceded they are binding. If the court looks at what the agency has actually done, and the initial determination is at 367, where the agency actually offers an explanation for why a consumed contract is in fact to be treated as a terminated contract, to the point where the computer system that the government uses to manage healthcare data rejects the data. And then you compare that to its completely different position articulated in one line at 375, there is no explanation for that change in position. And whether we advocated something differently or not, an agency decision rises and falls on the agency's explanation that it actually offers. There is no explanation from this agency other than post hoc rationalizations, including discussion of things that actually aren't even in the record that this court has before it.
All right. Thank you.
Thank you.
Stand, please. This honorable court has sent your permission to the 138.